Hello friends, in the series on the income tax cases, today we will discuss a case which is on section 56 subsection 2 clause 7b, which talks about the angel tax. Although angel tax has been abolished by Finance Act 2024, but if we see the history of income tax, then it is very common for the legislature that they introduce one provision, after some time they find it inappropriate or not good for the taxation system, they discontinue those provisions and again they reintroduce those provisions. So in India, no provision can be said that it is abolished forever or something like that. It can be reintroduced at any time. So the deliberation on this case is very important as far as the angel tax is concerned, and it throws light on a very important issue, that whether section 56 subsection 2 clause 7b in the form of angel tax will be applicable for those issue of shares which are allotted to the existing shareholders in a right issue. This issue has been taken by Ahmedabad ITAT A bench in the case of Tiki Tar Industries Baroda Limited versus Principal Commissioner of Income Tax, and this case has been reported in 113 ITR Tribunal at page number 388. The date of the judgment is 24th January 2024. In the present case, the assessment year is 2014-15 and the Assessee company issued 5 lakh equity shares of the par value of rupees 10 at a premium of rupees 50, and the Assessee company received during the year 2.5 crore securities premium. During the assessment proceedings, the Assessee submitted the valuation report under Rule 11UA. In the present case, the shares were issued to the existing shareholders, and the existing shareholders have given some loans to the company, and these loans were converted into the share capital. And when this 11UA valuation was taken by the assessee from the valuer, in taking that valuation, the loans of the existing shareholders were not deducted, but the assessing officer accepted the valuation report of the assessee and didn't make any addition on section 56 subsection 2 clause 7b, that is angel tax. When Commissioner of Income Tax observed this thing, that loans has not been deducted while calculating the fair market value, he was of the opinion that the fair market value has been calculated at a higher figure, that is why the section 56 subsection 2 clause 7b has been skipped. So this case deserves to be revised under section 263. So he initiated the proceedings under section 263 on the ground that in calculating the fair market value, the loans from the shareholders have not been deducted. The assessee filed the appeal to the tribunal, and this appeal was delayed by 262 days, and this condonation was allowed by tribunal by relying on the judgment of Collector Land Acquisition versus Ms. Tiki, which has been decided in 1987 and which has been reported in 167 ITR at page number 471, and this case has been decided by Supreme Court. When this matter was heard by tribunal, the tribunal was of the opinion that it is not important in the present case that whether the loans have been deducted in calculating the fair market value of the shares under Rule 11UA, because it is a well settled law that the provisions of section 56 subsection 2 clause 7b, that is angel tax, does not apply in a case where the shares have been issued to the existing shareholders in the form of right issue. So whatever may be the value of those shares, it doesn't matter, and since section 56 subsection 2 clause 7b does not apply to a right issue, so the question of deducting the loans from the question of deducting the loans for calculating the value of shares under Rule 11 UA does not arise. So the tribunal gave the decision in favor of the assessee and said that in the present case the Commissioner of Income Tax has misapplied the provisions of section 56 subsection 2 clause 7b, and in the present case the revision is not correct in the eyes of the law and quashed the addition. At the end of this video, once again I am repeating the name of the case. The name of the case is Tiki Industries, Baroda Limited versus Principal Commissioner of Income Tax, and this case has been reported in 113 ITR Tribunal at page number 388, and the date of the judgment is 24th January 2024, and the matter has been decided by Ahmedabad ITAT A bench. Thank you, friends.